PERM processing delays. What is happening? Why is this happening? And how can we deal? This video is designed for HR professionals, employers, anyone within a company that is helping foreign nationals navigate the employment-based green card process and foreign nationals themselves. So first, let's talk about what is PERM. PERM stands for, or is part of the green card, the employment-based, it doesn't stand for, but it's part of the employment-based green card process that most foreign nationals have to go through if they're going through an employment-based green card process. There are different types of processes available, such as the national interest waiver petition, foreign national of extraordinary ability, the researcher and professor category, multinational managers and executives, but most professionals or most individuals who are going through the employment-based green card process go through this PERM labor certification process. And there are three major stages to this process. We have a lot more information on in our video library called Sumner School Business Immigration Basics about the overall employment-based green card process, including those other classifications that I mentioned. But the PERM labor certification is the first major stage in this process. So we're seeing a lot of delays. I'm sure this is not news to anyone who has even looked into the employment-based green card process, but we're seeing a lot of delays. It's taking longer than it has historically to get through this first stage of the process. So let's back up for a minute and talk about why PERM is important, or why the employment-based green card process is important. First of all, of course, it's a way for a foreign national to be sponsored by their employer for permanent residence here in the United States. So if you are an employer, for example, an HR professional, manager who has a foreign national employee on your team within your company that you would like to retain long-term, then probably, have a conversation with us or another qualified immigration lawyer. But probably that is a long-term strategy to retain them, to make sure that they're able to stay long-term and work for your company here in the United States. So obviously a way to get a green card through the employer. But there's another key component to the employment-based green card process for many foreign national employees and their employers. And that is that if a foreign national worker is in H-1B status, which not everybody is, and you do not have to be in H-1B status in order to go through the PERM green card process, the employment-based green card process. A lot of times you are, but you don't have to be. You don't even have to be in the United States. But if you're in the PERM process, or in the H-1B status rather, that status is valid for up to 6 years total. One person can hold H-1B status for up to 6 years total, with the exception that you can extend beyond the H-1B, beyond the 6th year in H-1B status, if you are at a certain point in that employment-based green card process. Namely, if you have an I-140 petition approved, you can extend for 3 years at a time beyond the 6th year. Or if you at least have filed the PERM labor certification, or the I-140 if the PERM isn't required, such as one of those other classifications. If you have filed the PERM at least 365 days before the end of the 6th year, you can extend in 1-year increments. There are other requirements and exceptions to that, of course, but generally speaking, that's critically important for a person who's in the United States in H-1B status. So that's why it's important. You may be thinking, if you have H-1B workers, you may be thinking, okay, they have another 5 years left. I'm not ready to deal with this yet. And that's fair. That's fine. There are other considerations, but it is something to at least have on your radar. So let's talk about why it's taking so long, how that impacts both employers and employees, and what you can do about it. The reason that the PERM labor certification process is taking so long, there are several reasons. One is that the preparation process itself takes a long time. So if you are used to the process of filing certain non-immigrant visas, petitions or applications such as having your employees apply for a TN at the port of entry, or perhaps at the consulate in Mexico, you might have to wait several months to get an appointment, for example, for that appointment at the consulate. Or if you're used to filing H-1B petitions, sure, it takes several months to process. For the PERM labor certification process, from the time you start the process until the time you're able to actually file the PERM labor certification application, we're not even talking about the government waiting time once it's filed, but from the time you start the process to the time you're able to file, usually is a matter of at least, I would say, 8 to 12 months. The reason is, first, you have to gather all the documentation, get together the case strategy, and that's something that the attorney does, at least in our office. That's what the attorney should be doing. That's what we do. But then we have to file what's called a prevailing wage request with the Department of Labor. And right now it's taking about 6 to 7 months just to get that prevailing wage determination back from the Department of Labor. So you have 6 to 7 months there. You have some time on the front end to get together the case strategy, make sure you have the required documentation, get that prevailing wage request, then you conduct recruitment. We walk employers through that, our clients through that step by step. But that process is going to be a minimum of 60 days because you have to place something called a job order. You can overlap the recruitment with, waiting for the prevailing wage determination. There are pros and cons to that. That would be a separate video. We can talk about that in a separate video. But just in general, we conduct the recruitment once we have the prevailing wage determination. So you're looking at, realistically, at least 8 to 12 months from the time you start to the time you're ready to file. Once you file the PERM labor certification right now, and this is the second reason that PERMs are taking so long, the Department of Labor is taking approximately 16 to 17 months right now to process a PERM labor certification application. There is a backlog of cases. The Department of Labor is not fee funded. They're funded by the federal government. So they internally decide, how to allocate their resources and their time, and they have other obligations as well. This is not their sole obligation to process PERM labor certifications. They also have to process seasonal work applications, such as the H-2B and H-2A programs, and then there are other functions, of course, that Department of Labor has as well. So the bottom line is we, unfortunately, don't have any control over how long it takes, but right now we're seeing that it's taking the Department of Labor at least 16 to 17 months to process a labor certification application once it's filed. So that's, the year-ish processing time or preparation time, then filing 16 to 17 months. We are seeing personally, or rather within our practice, we're seeing a slight increase in the number of requests for evidence. That used to be known as a PERM audit. When they ask for additional documentation, that can slow the processing time down as well. Really, so far, we're seeing that in cases, almost always in cases that have kind of what we consider triggers. There's nothing that you can do necessarily proactively. So for example, if the employee is on E2 status, a lot of times we see requests for evidence then, and there's certain other triggers as well. So these, for better or for worse, are not ones that were unanticipated, but we are seeing those. The other factor with PERM processing times is premium processing is not available. That's a service that USCIS, which is a completely different agency from Department of Labor, offers only for certain types of filings, but premium processing is not available for PERM labor certifications. And honestly, I've never heard of an expedite request being honored with Department of Labor. I don't have a lot of experience with that. I've had clients, ask about that over the years, but ultimately we haven't had to go that route. I've never heard of the Department of Labor or the Department of Labor honoring an expedite request. So it kind of is what it is. We're kind of stuck with the system here. So generally speaking, from the time you start the process to the time that you have that PERM labor certification application approved, realistically is going to be at least 2 years, perhaps closer to 2.5, or potentially even 3 years. That's a really long time. So backing up for a minute, when we're talking about why this process is so important, of course, it's a way to get a green card, like I said, an employment-based green card, but it's also a way, it can be a key strategic way to make sure that your foreign national worker is able to continue working in the United States beyond the end of the 6th year. So again, if you have employees or an employee who is in their first, second, maybe even third year of H-1B status, if you are the employer or HR or supervisor, you might be thinking, we have time. Talk to an immigration attorney, come up with a plan. Even if you don't decide to move right now, at least have a plan in place as to tentatively, at least when you're going to begin that process or start thinking about that process, because time flies, as everybody knows. And the processing time, just the preparation time and the processing time really is quite long. So you don't want to wait until that employee is in year 5 or perhaps even 4 of the process or the H-1B status, because it could be too late. You may at that point have a gap between the end of their 6th year and the time that they're able to resume working. So what can you do about that? And just to, again, to talk about that for just another minute, like I said, you do not have to be in H-1B status to go through the PERM process. You can be in any number of other visa classifications or outside of the United States. But remember, in order to extend beyond the 6th year, you have to either have the I-140 petition approved, or you have to have filed the PERM labor certification at least a year application before a year before the end of the 6th year. The I-140 approval, you can't get that until you get through this I-140, this PERM labor certification process. So this 2 or 3 year long process. So that's the reason I'm saying it's so important to at least have a plan. So what can you do to avoid these processing delays? Like I said, there's really not a lot that you can do to avoid it. It's largely outside of our control. But as with anything else in life, let's think about what is in our control and what we can do to prevent stress down the road. So one thing is, like I said, to plan ahead. Even if you as a foreign national employee aren't really worried about it, maybe you just were selected in the H-1B cap, at least have a plan. Maybe start initial conversations with your employer, have a plan as to when you at least want to start thinking about initiating this process. I recommend that at least within a year, a year into the H-1B process, at least have a conversation internally and think about when you might want to begin the process, because it does take a while to get through. And a lot of times within an employer, there's as it should be, there is a process that you go through internally, right? To make sure that you have the budget in place for this, to make sure that everybody's aligned and on board with this process and making sure that it's an appropriate time. So sometimes there are multiple levels of approval that you have to get to go through. So you don't want to wait until the moment that you think you should start the process. You want to backtrack and think about, okay, when should I start those initial conversations? So plan ahead. At least a year or two into your H-1B status, you want to at least be thinking about this to avoid last minute scrambles. It is so stressful. I have been there before with clients who, sometimes through no fault of their own, are at the end, towards the end of their 6th year in H-1B status, and it's incredibly stressful for everybody involved. So you want to avoid that if at all possible. The other thing that we can do is to build in buffer time. Like I said, there may be internal processes that you have to go through as an employer, which is totally expected. You want to make sure that you're investing appropriately and doing this at the correct time. So there are internal conversations or perhaps multiple levels of review or approval that you're going to have to get, and that takes time. So build in buffer time for that. Build in buffer time for the fact that if you are, hopefully you're working with a lawyer for this, I highly recommend not doing this, not trying to do this on your own. It's probably not going to go well. Anyway, if you're working with a lawyer, at least in our office, we make sure that the foreign national and the employer, but especially the foreign national, has the documentation that will be required at the I-140 stage before we even begin the recruitment. So really before we we submit the prevailing wage request. So early on in the process, we want to make sure that the employee has the required, for example, the required degrees, transcripts, and importantly, the experience letters. We'll have a separate video down the line about I-140 experience letters, but those are critically important that those be aligned with the requirements of the position, which are, that's a whole part of the case strategy. And it takes time to get those, sometimes to get those experience letters. So build in buffer time. Don't assume that, oh, I want to start this by the beginning of year 3 of H-1B status. So let me begin the process, the conversation. Then no, build in buffer time, leave in room for lots of discussion, lots of planning, gathering documents. And then, like I said, having those documents available. You do not want to you don't want to wait this whole 2 or 3 year time frame for the I-140, for the PERM labor certification stage, and get to the next stage, which is the I-140 petition, and then find out that you can't get those letters of experience that are required, because you would have to start the process all over again. So it's critically important that you have those documents and really take the time to make sure you have the documents that are going to be required and that are clearly going to check those boxes for the I-140. You'll be so glad that you did. So what can you do next? If you are an individual foreign national employee here in the United States, first of all, we are so glad that you're here. We need your talent and your cultural contributions, personal contributions. We're glad that you're here, and we hope that you stay. So if you are here in the United States as a foreign national worker, think about where you are. Think about having kind of a longer term strategic plan for your immigration process, especially if you know that you want to stay here longer term. If you are in H-1B status, think about how much time you have left and when to initiate that conversation with your employer. And I know it can be scary, right? Because it's a pretty big ask to be sponsored for permanent residence. But it's entirely possible that they are interested in that as well, and perhaps need some, some education, or they want to initiate that conversation. So you never know. But be thinking about that if you are a foreign national here in the United States, even if you're not in H-1B status. If you are in a different classification, like I said, it's absolutely possible to still go through the employment-based green card process. You may have other things to consider as well, such as dual intent, and we have another video on that as well. But know that it's not limited to H-1B workers. If you are an employer, let's come up with a plan. I love helping employers come up with strategic plans like this. And as I said before, there are multiple considerations. So it may be that you don't begin the PERM labor certification process immediately for everybody who's eligible, or for maybe anybody who's eligible, but you know that you need to do that in the next 12 months. And so you build that into the 2026 budget and the 2026 kind of strategic plan, or your task list for 2026 or beyond. But let's come up with a plan. Let's look at it. And there may be, I know I have some corporate clients that say, okay, we will sponsor this type of position, but not that type of position. So it may be that you need to have a clear sponsorship plan in place. But whatever it is, let's come up with a plan. Everybody will feel better. I feel like just in general, both employers and employees, and us as immigration lawyers, feel really great when there's a specific plan in place that's really intentionally thought out. And we are here, we are happy to help you with that type of thing. I hope that you have found this information helpful. If so, I hope that you will share this video with a friend or family member or colleague. Make sure that you subscribe to this channel so that you don't miss our next video. Otherwise, my name is Emily Sumner with Sumner Immigration Law. We help clients around the world and around the United States with family-based and employment-based immigration matters. Until next time.